Negotiations on an EU-US trade agreement, the Transatlantic Trade and Investment Partnership, known as TTIP, began in June 2013 with the aim of establishing the biggest free trade and investment area ever envisaged between the world's two largest trading blocs. Negotiations are taking place in the most secretive environment imaginable, with scrutiny by elected representatives confined to heavily redacted and purposely selected documents. Yet despite this, the level of opposition to TTIP is greater than anyone could have imagined. Millions of people across Europe have expressed opposition to the fact that TTIP could have a devastating impact on our local economies, on workers' rights, on the environmental standards, on vulnerable sectors such as Irish agriculture. But the greatest cause of concern across the EU regarding TTIP is the inclusion of an investor-state dispute settlement mechanism, the ISDS. Put simply, this means that there will be a provision, denied to everyone else, for corporations to sue sovereign governments who implement measures that impact on the profit-making potential. These measures could include public health, environmental or employment provisions aimed at protecting citizens. In fact, 97% of the replies that the European Commission's own consultation received last year rejected the inclusion of ISDS in TTIP. Despite this overwhelming public opposition, negotiators have pushed on ahead. In an effort to minimise the huge levels of opposition, they've tried to repackage ISDS, and in this vein, the Commission recently proposed a new European Investment Court. Commissioner Malmström has attempted to differentiate the ISDS and the newly proposed court system by arguing that having a permanent court will ensure judicial independence, an appeal system and a code of conduct. What she doesn't mention, however, is the impact that this court will have on the sovereignty of our own national courts, and it's this aspect that makes this proposal especially interesting. As it stands, this new court would hear cases coming directly from investors who have suffered losses in cases of direct and indirect expropriation, and cases where a change in the legal and regulatory framework would negatively impact the operation of an investor's expectations of profits. But the ability to grant compensation for such claims is an entirely new jurisdiction for this investment court. A jurisdiction not previously granted to the European Court of Justice or any other court to which Ireland is subscribed to. As such, the question I now raise is whether this court is compatible with Bunreacht na hÉireann, the Irish Constitution. In this case, we're not witnessing the addition of a layer to an existing structure, but an entirely new jurisdiction altogether, and a jurisdiction that will hugely impact on the future development of the law in Ireland and the ability of Irish governments to legislate freely when it comes to public services, a jurisdiction that has never before been ceded to a European court. On top of all of this, there will be no engagement between the investment court and national courts. The creation of this new court will vastly change the judicial landscape in Ireland and many other European countries. It will open the taxpayer up to liabilities never previously imagined. I have sought formal legal opinion from a senior counsel, but the preliminary legal advice that I've received clearly states that my initial thoughts were well founded. The adoption of an investment court as proposed by the Commission would create a new jurisdiction, which in turn will require a change to the Irish Constitution. What this means in effect is the worst nightmare of the European Commission and governments such as those in Dublin who want to push TTIP through against the wishes of the concerned citizens and with as little public debate as possible. It would mean a referendum in Ireland on the new investment court, which would naturally become a referendum on TTIP itself. Such a referendum in Ireland would undoubtedly lead to calls by citizens in other EU countries for them to also be allowed to give their verdict. Ironically, it will be the Commission's attempt to ignore the opinions of the people of Europe that will actually give the greatest possible voice to the people. I expect formal legal opinion to be presented to me in early 2016, but undoubtedly this is the potential to be a turning point in the entire TTIP debate, not only in Ireland but across Europe. What we need to do now is to continue to engage in an open and honest debate about the real dangers of what TTIP and the investment court would mean for the people of Ireland and Europe. With the prospects of a referendum, proponents of TTIP will no longer be able to hide from this debate. Put simply, this could be the beginning of the end for TTIP.